I'm going to talk to you today about common mistakes in family court. Most lawyers and most judges view restraining orders as just a routine matter in family court. I've heard many judges make the statement, "Sir, are you going to harass, molest, bother, interfere with your wife?" Or they'll say that to the wife. The common response is, of course not. The judge's approach will be, well, then a restraining order is not going to harm anything. It is a safety measure. However, it should be regarded in a more serious manner. Do not just automatically agree to a restraining order because it may have serious ramifications for you. Number one, if a restraining order is not worded correctly, it could invoke what's called the Brady Bill. And what the Brady Bill basically provides is if you have a restraining order on you, you cannot own, possess, or use firearms. That may interfere if you're a hunter, a target shooter, or you have guns in your home. Make sure that the restraining order is written in such a way that if it invokes the Brady Bill, that it will become invalid. Another thing in regard to the restraining orders that are routinely agreed to by both lawyers is this. If something happens, an altercation between you and your spouse or significant other, if there is a restraining order against you, the police are going to take a different point of view immediately, because if they come out, whether you are guilty or not guilty or even being set up, the first thing they're going to see is you have a restraining order on you. Why are you there? Why are you arguing? Of course, the best thing to always do, if you see a situation getting out of control, withdraw from that situation. Do not continue, particularly during times of visitation. Visitation is for the child's benefit. It is about the child. It is not the time to continue your disagreements or settle differences between you and your spouse. If you or your spouse are engaging in that kind of conduct, a judge is going to reprimand you very seriously, and appropriately so, because you do not want your child having that upset stomach or tension on every visitation that may last for years. When you also go in, just do not routinely agree to attorney's fees. That is the negotiation process. But as with all matters in family court, there are 2 points of view. Everything is subject to negotiation. Make sure your attorney is fighting for your position.